up through. I did not see the March 4th reply until this afternoon, so I may ask that you walk me through those, which you all do so well anyways. Okay, this is Judge Alyssa Perez presiding over the 210th District Court civil docket for March 6, 2024. All matters being heard today are being heard in accordance with all orders and directives regarding remote proceedings. In addition to that, we are streaming live on YouTube for public viewing. I'll go ahead and call our case. It is cause number 2021 DCV 3996. Paseo del Este Municipal Utility District Number 1 versus the City of El Paso, Texas. El Paso Water Utilities Public Service Board. May I have announcements, please?
Your Honor,
yes, Ryan Green on behalf of the plaintiff, Paseo del Este, MUD number 1. I've also got in the courtroom with me Harold Davis, Paul Terrell, and Jeff Kirschbaum.
Your Honor, on behalf of the El Paso Water Utilities Public Service Board, buying through the City of El Paso, Stephen Weller for EP Water, and then Gunnar Sequist, who is a partner of mine at Bickerstaff Heath, and of course, Patricia Borshaw, who is the Assistant General Counsel for EP Water. Pleased to be here today, Your Honor. Thank you for the time.
Thank you very much, counsel. And so we have our motions for summary judgment both set today. As I was mentioning just briefly before we got on the record, there is a reply filed March 4th. And frankly, I don't believe I had gone through the February 28th motion, response to motion for summary judgment. So let's start with you, Mr. Davis.
Your Honor, Harold Davis, Mr. Green.
My apologies, Mr. Green.
I was going to announce one procedural thing, Your Honor. What we've agreed with the defendant is their cross motion for summary judgment alleging that legal issues apply in this case, rather than hear our motion and then turn around and hear the PSB's motion, which is basically the flip side of our motion. We're going to do it as one motion with the plaintiff going first through Mr. Green.
Thank you very much. My apologies, Mr. Green. I wasn't trying to ignore you or just, I hadn't usually seen you. So, Mr. Green, you may proceed.
Yes, Your Honor, no offense taken. I haven't had the opportunity to appear before you before, so I completely understood. So this is a contract dispute. Both sides, plaintiff and defendant, are in agreement that the contract is unambiguous as far as our motions for summary judgment, and we're just asking the court to decide which one of us is correct in reading the contract. My client, Paseo del Este Municipal Utility District Number 1, it's a governmental entity, and it is the purchaser of water at wholesale from the defendant, El Paso Water Utilities Public Service Board. I know that throughout our motion, we called them the PSB. In their motion, they call themselves EP Water. I may use that interchangeably, but I will use the word Paseo to refer to my client, the wholesale purchaser under the contract. This is a 2003 contract. The parties have been operating under it for almost 21 years now. But this issue arose back in 2021, just 3 years ago. And the situation is, after about 18 years under the contract, following the billing methodology, the rates that are charged to my client by the defendant, EP Water, after 18 years of the methodology being done the same way, they changed up the way our rates were calculated. And they did that unilaterally. That was not something that we agreed to, and that's why we're here. We filed this lawsuit initially, Uniform Declaratory Judgment Act, asking for declaratory judgments that our reading of the contract is correct. We've set aside the money, that the excess money that they're saying they're owed under their approach, but we haven't paid it to them. And in response, they filed a counterclaim for breach of contract, saying, no, our version of the contract is correct and you owe us all that money. That's the fight. And like Mr. Davis said, these are just mirror image issues, and it all boils down to the same question: can the defendant unilaterally alter the billing methodology the way that they've done? So I'll start with the contract itself, looking at the language. And the key point on this is the distinction between a formula a methodology, a formula that remains unchanged, while the numbers that plug into that formula get updated over time. That's the key from our perspective to what the contract does. And Your Honor, I'm going to try to share the screen if I can.
There we go. Okay.
All right, is that working?
Yes.
Okay, excellent. So the contract is Exhibit 2. And I'm using the response. My response has the same exhibits as the motion, but a few more. So I'm just going to stick with that. So Exhibit 2 to our response is the 2003 contract. And to look at the provisions relating to the rate, we go to sections 4.1 and 4.2, and I'll just jump right to those. So section 4.1 here starts at 28 of the contract, page 28. I'm going to scroll down. I'm actually going to start with section 4.2, the rate methodology, because this is demonstrating that key point that there is a methodology that is set while the numbers that plug in get updated. First sentence here of section 4.2. The cost of service methodology used by the PSB to establish the PSB wholesale rates as described in Exhibit J applies to the development of rates for both retail and wholesale services. So going forward under the contract, you have the initial rates, and then the rates get developed every year. The cost of service methodology on Exhibit J will remain the same. And it talks about how that methodology involves different allocations. And then you look at the last sentence of section 4.2. The cost of service analysis is updated annually using current cost and customer information. So that's not saying they get to change the formula whenever they want, but rather the cost and customer information that apply this year get plugged into the existing methodology, the formula. Section 4.1 indicates the same thing, and I'll go back a page. Actually, I'll stay on the same page to show the key sentence. And it's the second full sentence on the page, which says, the PSB agrees to use the same methodology that it used to calculate the initial PSB wholesale rates, which methodology is set forth in Exhibit J, to fix the PSB wholesale rates for the district in the future pursuant to the contract. Same concept. It's the same methodology. It not only was that methodology used to establish the initial rates that when this contract was entered, but going forward into the future pursuant to this contract, we will use the same methodology. And then we continue on to this paragraph, and it talks about updating the numbers plugging into the methodology. The part of the rates for water and wastewater service supplied to this contract consisting of the PSB wholesale rates shall be automatically adjusted as the PSB adjusts its PSB wholesale rates, again, under that methodology. So since I've mentioned Exhibit J twice, both section 4.1 and 4.2 of the contract refer to this Exhibit J. I'll turn to that now. And that is Exhibit J to our Exhibit 2, the contract. And this is what it looks like. It has all these figures, and it comes down to costs, and you have a second page, and it has it all worked out. And so that is the calculation of the rate. Now, Your Honor, you don't have to understand all of the different pieces of this, and I'll explain why in just a second. But suffice it to say, this is the Exhibit J. It wasn't some mystery. It's a 2-page document that was actually attached to the contract, and this is the methodology that we contend has to continue to be applied every year under this 60-year contract. And they don't get to 18 years in, change that up. Now, here's why I said you don't have to understand all of these numbers. You don't need to be a rate expert. And this is a key point. There's no dispute that the rate methodology as set forth in this Exhibit J did the two things that we're saying they did. And here are the two things that they changed 3 years ago. Number one, there is a 10% surcharge that the EP Water pays to the city of El Paso. It's out of net revenues. They pay 10% of it upstream. Well, that was never handed down to us. They didn't add a 10% surcharge to us or any of the other wholesale purchasers. And that is right here in Exhibit J. Payment to the city. They're pulling this out as a cost exclusion. And I'll expand it to see you leaning forward. So so they have the costs of the O&M, the operating maintenance, and they pull out this, that's the 10% that they're now wanting to put back in, 10% surcharge. So that's one thing. They want to now, because they have to pay upstream the 10% surcharge to the city, and they've had to do it since the 50s. All of a sudden, 18 years into the contract, they want to remove that cost exclusion. The second thing they did is they changed the way that the rate methodology calculates the peaking factors. And so there are these wholesale units, and again, this is not disputed. These wholesale units are system-wide. The way the peaking rate, what that means is at the highest usage during the day, when the usage of the water is highest, the system needs to handle that. And so they use that highest peak in order to help set the rates, what they're charging. When this methodology was agreed to, we didn't even have individual peaking data, but there was system-wide data, and the parties agreed to put into this methodology the system-wide numbers. There's nothing in the contract that says, but on down the road, we'll change up that methodology and start using individualized peaking data. Not at all. Exhibit J uses the system-wide peaking data that's baked into the methodology, and there's no dispute on that. All right. So there's no dispute that the methodology as it existed when the contract was entered did not charge us the 10% surcharge and used system-wide data to calculate the peaking rate. There's also no dispute in this case that they changed both of those unilaterally, like I said, in 2021. And I'll just jump over to a document in the record. This is Exhibit 6. This is an email from the defendant to the plaintiff to us explaining the change. It's dated April 9, 2021. They talk about these two changes to the wholesale rate for the fiscal year 2021-22. They talk about how in previous years, they did not, they used a system-wide peak demand. That's true. And now they're going to change that. They think that we should be responsible for doing an individual calculation instead of a system-wide. That's their unilateral change to how the peaking demands are calculated. And then they describe the 10% surcharge here as well. They acknowledge that in previous years, they did not charge us a 10% surcharge. They decided now that that was a mistake and they shouldn't have done that. And so they say that we have eliminated the credit to PDE, just like I said. So not in dispute. They changed it unilaterally. And then they go on to concede that these are changes in the calculation and that they have a significant increase, that cause a significant increase in our wholesale water rates that we have to pass on to our customers. Remember, we're a utility ourselves. We're a wholesale purchaser of the water. We are a retail water provider to our retail customers, houses, businesses. And so by those two increases on down the line, that increases the rates to our folks. Our position in this lawsuit is that we're entitled to the benefit of our bargain. And our ratepayers are entitled to the benefit of our bargain. They don't get to change it up. All right. So going back to that key point then, and this really is the key point for the court to decide. Can they change the methodology itself, or can they just change the numbers that plug into it? And so I'll go back to that Exhibit J. So what they've done is they haven't, let me reduce that a little. They haven't altered, so these cost exclusions, the 10% that's right here, they haven't altered those numbers based on changes in what the city has to pay, what EP Water has to pay. What they've done is they've outright removed that cost exclusion. And our position and the way that the contract is written, the contract, it acknowledges that amounts will need to be updated, quote unquote updated, in the same quote unquote methodology. When you keep the methodology the same, you can't remove a line item. You can only update the numbers in the line item based on what the actual numbers are. And they've done that for year to year. Remember, for 18 years, they kept it the same way. There was no 10% surcharge charged. They decided to remove this line item from our methodology. And they're saying, well, we get to do that because we're doing it for other customers. Well,
Let me ask on that 10%, the 10%, so seeing it here as, I don't know if I had realized this in Exhibit J, the payment to city, was that, am I to understand then that when in the contract, I guess El Paso Water was already in a position where it was paying that 10% to the city?
yes.
I mean, it's the same thing. It didn't change. It wasn't a new, okay. All right, go ahead, Mr. Green.
Yeah, absolutely. And that's in the record. It's the payment up to the city is based on an ordinance that was passed, I believe, in the 50s.
Okay.
Yes, that's exactly correct. So that's the point on the 10% surcharge. They can't change the methodology. They can only update the numbers in the methodology. That's what this court needs to decide on the contract issue on the 10% surcharge. Similarly, the peaking data, it's undisputed that these numbers are based on system-wide. And so the question is it a change of methodology?
Hold on a second, Mr. Green, let before you go forward. Okay,
yes.
So Exhibit J details the methodology, right? The methodology,
Yes.
and we're talking about basically what can change are the numbers you plug into this methodology. So if there is a line item for a payment to the city that basically shows a credit as if it did not exist, why? I mean, the numbers that you plug in could just now, rather than be a credit, be something that is charged per this methodology. Is that not right?
So this payment to city line, that's part of the agreed methodology. We're agreeing, the parties are agreeing that there will in fact be a cost exclusion of the payment to the city. We're agreeing to that. Okay. That's the point on it. And so if that was right, they could do anything they wanted to these two pages. But you have to bring meaning, you have to give meaning to the provision of the contract that says the methodology will be the same. Again, we'll go to it. This is section 4.1. The PSB agrees to use the same methodology. That methodology includes a cost exclusion of the 10%. We don't have to pay it. And that's what we're trying to enforce, that we understand that things can be updated, but this court has to give meaning to the contractual phrase, but they're going to use the same methodology. And where is that methodology? It's the methodology set forth in Exhibit J. That's how we get there. So, and let me, I didn't mention this, and I need to mention it just so the court understands. There's also a second amendment to this contract. That was done in 2007. There were discussions back and forth in 2005, 2006 about different things that they might charge us differently. And they couldn't do those changes without us agreeing to them under the contract. And so the parties agreed to a second amendment. That's Exhibit 3. And I'll jump over to the Exhibit J just so that the court understands that when I'm talking about the Exhibit J, it was tweaked in 2007. This is the Exhibit J in the second amendment, but the same things are there. The 10% surcharge is still a cost exclusion, and the peaking is still being calculated by system-wide. So I don't want to mislead the court that Exhibit J was unchanged since 2003. It was changed once, 2007, but the two key points that we're focused on, they never changed. And that's significant because the parties changed other things. If EP Water thought that, oh, we need to make sure that we can switch calculations of peaking data over to an individualized, it needed to be included in Exhibit J as part of the agreed to methodology, and it wasn't. Same thing with the 10%. If they thought they could change that, then here was their opportunity to get that changed by an agreed amendment to the contract. Now, the 10% surcharge, I think, is fairly straightforward. It's a line item. They can't just pull out the line item. The peaking data is a little bit harder to wrap your arms around, I think. What the heck are those numbers? And so I'm going to turn over to page 6 of the defendant's response to motion for summary judgment. They prepared this chart these bars, blue versus gray, is the peaking data. And blue is our individualized peaking data. Gray is their system-wide peaking data. And you could see the huge difference. You can see why we wouldn't want to pay, and we wouldn't have agreed to pay the individual peaking data when look at the system-wide way down here. When the methodology can be updated so that we're charged, no dispute, in 0708, we're charged using this gray bar in the peaking data. No dispute that from the next year, they get to go from 1.92 to 1.93, and then to 2.20, and then to 2.03. That's updating the methodology with the current numbers, all the way down to 1.8 at the end. But what they did instead, and this is the change in the formula, the change in the methodology, rather than using the same methodology, they switched from the gray bar to the blue bar. That's what they did. And so this picture perfectly encapsulates the change they made to the methodology. We're perfectly fine with them increasing, decreasing as the gray bar increases, decreases. What the contract doesn't allow is to change methodologies and swap over from the gray bar to the blue bar. So that is the contract issue. There is one other aspect to the parties' cross motions that I'll turn to next. In addition to the question of what does the contract say, that the court needs to decide, there's also a question of Texas statute. As Your Honor saw, much of EP Water's motion or response initially dealt with all these different laws that they're saying, well, if we followed your view of the contract, Paseo, we would be breaking the law. And that's just not accurate. And so I'll run through this really quickly. All of these sites are in the parties' filings, but the statute we're relying on is Texas Government Code 791.026. This allows for contracts for water supply. That's what we're talking about, wholesale water supply. And it says that the contract may contain terms and extend for any period on which the parties agree. And that gives us the authority to say we have the right to contract around what the law might otherwise require. There may be some other laws that apply to how wholesale rates get set, but the Texas legislature, valuing the freedom of contract, has given municipalities, districts, we're a district, the ability to contract as they see fit by agreement. And then the key phrase, of course, is subsection G. The powers granted by this section prevail over a limitation contained in another law. 4 cases have been cited in the parties' summary judgment filings, and the point of those 4 is to say, this is true. The contract that we've entered into are valid, is valid, excuse me. It's not illegal. The terms do get enforced by courts. Now, that being said, because we're public utilities, we are still subject to the regulation of the PUC, the Public Utility Commission of Texas. And so when the Public Utility Commission of Texas says you have to supply drinkable water, we don't get to say, no, we've contracted around that. So we're still subject to PUC regulation as far as what the PUC requires of utilities, but our contract as between the parties is valid, its terms are valid. And so the 4 cases, I'll look at them real quickly. City of the Colony case, a 2008 case out of Fort Worth. These all just have really small sections talking about the statute. In this particular case, parties have the right to contract as they see fit, as long as the agreement does not violate the law of public policy. And then moving on, the contract here sets forth a scheme by which the colony and Frisco pay the district to accept and treat the wastewater. So this falls under 791.026. As addressed in the preceding section, the government code expressly allows for this particular type of contract, and there's the cite to the statute we're relying on. Contrary to the colony's argument, the government code reflects a public policy that permits the execution of this particular type of agreement. So in other words, the law allows it. Next case is the Texas Water Commission case, and short case. This deals with the issue I was talking about, that just because we're allowed to contract doesn't mean we're not subject to the PUC regulation. So the water code provision here talking about that a retail public utility receiving service from another retail public utility may appeal to the commission a decision that affects the amounts paid. The PUC still has jurisdiction of rate disputes if the parties want to go there. And the court goes on to look at 791.026 and indicates that, yes, this does allow contracts, but the water code still gives the commission jurisdiction over contractual rates. And so the same thing, the PUC does have jurisdiction, but that doesn't mean that the court won't enforce the contract as valid. Bear Metro essentially does the same thing, and I'll skip that and head straight over to City of Ranger just to wrap up.
I'm sorry, sir. What was the other case called?
The other case,
is Bear
as I said,
Metro?
it's cited, it's Bear Metro, 185 Southwest 3rd, 546. And and I'm happy to go through it. It's the same thing. It's talking about, look, that 791.026 section does not supersede requirements for the PUC, but it makes clear that the legislature's intent to allow municipalities to obtain the required capabilities to operate and construct water systems through contracts, and it's believed that these contracts increase the efficiency and effectiveness of local governments. Again, contracts are great. Yes, we're still subject to PUC regulation if we need to go to them. And so again, the last opinion, this is the City of Ranger case. This is the exact type of contract we have here. It's a contract for supply of water from a municipality to a nonprofit rural water supply corporation. It's a wholesale water supply contract, just like here.
Mr. Green, if you'll back up, it cut out twice. If you could get back in.
Sorry about that. It's the same context as here. In this City of Ranger case, it is a wholesale water supply contract. And the court holds that the trial court did not err in interpreting the terms of the contract. That's what we're doing here. We can enter into this contract, the court can construe the terms. Furthermore, we hold that the trial court properly ruled that the contracts are valid and enforceable. The contract between EP Water and Paseo is valid and enforceable. These contracts do not interfere with the governmental or legislative power to regulate water rates. Again, PUC has regulation authority. We don't deny that, but this contract is valid. So that's the law. That's our response to all the legal issues that EP Water has raised. Get back to the contract, what we're really here for. And that's the ultimate question of when the contract says that PSB agrees to use the same methodology that it calculated the initial wholesale rates as set forth in Exhibit J, do we get the benefit of that contractual provision? And our position is, yes, we do. The methodology stays the same. They update the numbers that plug into the methodology. The formula stays the same. They can update the numbers that plug into the formula, but they can't alter the formula under the guise of updating or remove parts of the formula under the guise of updating, and that's what they've done. So again, both sides are arguing this contract's unambiguous. We actually have a trial set for May 9, but both parties are in agreement that this contract really should be just decided on summary judgment, look at its provisions, and determine whether Paseo gets the same methodology remaining, regardless of how the numbers that plug into them get updated. Does Your Honor have any questions?
No, sir.
Okay.
No, sir. Is that everything, Mr. Green?
Everything. I'm sure I'll want to do a short rebuttal, but yes.
Sure. Mr. Weller, go ahead.
Thank you, Your Honor. May I also share my screen?
Absolutely.
Thank you. Your Honor, are you able to see my screen here? It's a PowerPoint presentation where I
Yes, sir.
laid out some of these issues. Okay, thank you. Again, first of all, I want to thank the court for your time on this. I know that we've given the court a lot of paper, but we appreciate the court's review of things. The parties are in agreement. We think that this case turns on pure issues of law, which would be the terms of the contract or the application of the statutes to the agreed facts. what we have attempted to do is, in lieu of approaching this from the standpoint of, well, of a trial, we have tried to, as best we can, present everything that we think is germane to the court's review in our motions and in our presentation here. And just put these legal issues to the court and let the court make decisions as to what you think is the correct application of the law. So I'll skip this slide. Let me just lay some of the foundation here, talk about some of the laws that govern the rate setting process, and talk about what the contract says. The two disputed charges, as Mr. Green noted, are the 10% payment to the city of El Paso and the concept of using PDE's own water usage data to calculate PDE's rates. So first, the 10% payment. The 10% payment is a requirement that's been imposed on the utility by a number of bond ordinances adopted by the City Council of the City of El Paso. And what the 10% does specifically is it relates to 10% of the total received by the board from the sale of water. So it applies to water sales revenues. It applies to all revenues from all portions of the combined water system located inside or outside the city limits, meaning that it applies to not just in-city customers. It applies to water sales that may take place to wholesale customers outside the city limits, like PDE. The customers, and I'll get into more on this in a minute, but the customer-specific peak data is basically consistent with industry standards. EP Water uses customer-specific data to set water rates for virtually all of its retail and wholesale customers. EP Water has a system through which, if it has a new customer that has not established its own peak history, they will allow that customer to be put on system-wide data for a period of time until the customer builds up his own individual usage history. Because when the customer first comes online, they don't have a usage history. And that's what happened with PDE. They were put on system-wide for a period of time, but they were always going to go onto their own peak usage, and there's no way to accomplish the agreements in this contract without putting them on their own peak data. And I'll go through all that. Mr. Green is correct. All other claims in this case, other than the breach of contract and deck action claims, have been non-suited. At one point, PDE took the position that the 10% was an illegal tax or an exaction, impact fee, or an unconstitutional taking. All that has been dropped at this point. The matters before the court are just the breach of contract and deck action claims that are going both ways. Furthermore, there was another charge that was contested at one point called the conservation credit that was included, that was originally included in the original Exhibit J. It's not in there anymore because it doesn't exist anymore, and is an example of exactly how that rate methodology is a living, breathing thing and is not written in stone the way PDE would like it to be. That conservation credit charge has also been dropped because it no longer exists. PDE has withheld funds. All funds attributable to the disputed charges have been withheld. The contract does not allow them to do that. The contract has its payment procedures in section 4.3, which say that PD is supposed to make payments in 10 days. The contract does not say that the customer can withhold money, which is basically, they've gone through a self-help remedy here. They didn't make these payments in dispute, they've just withheld them. But they have kept them in an escrow account. They've already collected these funds from their customers, and they set them aside in an interest-bearing escrow account. So if the court were to render a judgment that PDE needs to pay some or all of these amounts, they would have funds on hand today to make those payments without having to go through a special assessment to their users. Let's talk for a minute about what the wholesale contract says. And I'll just go through some of the big points. There were several fundamental overarching agreements that were in this contract that make it a necessity for these two disputed charges to be passed forward to PDE. And it is not as simple as what as the situation where we can only update the rates. That's not what the contract says. If you look at all parts of the contract, that is not the correct way to harmonize all of its terms. So the first basic concept, which is, sort of the fundamental basis of a wholesale contract, is that the PDE agreed to pay cost of service rates. And this is an industry term in the water rate setting industry, which means that effectively PDE is going to pay rates equivalent to whatever cost EP Water incurs to provide it with potable water service. The concept of cost of service rates is as much a process as it is a term. It's basically the utility has, when you're sitting there in 2003 and they're trying to sign a contract with PDE, the contract does not, it uses general terms like cost of service, and PDE will pay our wholesale rates, and PDE's rates will be adjusted to accommodate these concepts. Because sitting there in 2003, the utility doesn't know what their costs are going to be 5 years down the line, 10 years down the line, 20 years down the line. So this contract with PDE, similar to the other contracts with its other wholesale customers, has these general principles in it, because in 5 years there could be new water quality standards imposed by the federal government that we might need to comply with, or there are expenses that come along all the time that are not anticipated. And so you have to have overarching concepts in the contract that say you're going to get cost of service, because we don't know what those costs of service are going to be from year to year. The second concept that's in the contract, which is very important, is the contract says this in a variety of different ways, that PDE's rates are not individualized and that they would pay the PSB wholesale rates. In other words, PDE's rates would match the rates EP Water's standard wholesale rate model that it uses to charge rates to its other wholesale customers. The contract makes no reference to individualized rates. It says you're going to pay the rates that other people pay. It goes on to say, another basic agreement, PD's rates shall be automatically adjusted each year using mandatory language, shall, that PD's rates could and would be automatically adjusted and updated to assure PD is accomplishing these two basic points: cost of service and rates on the same basis as other wholesale customers. This was the only way that the utility has to write a contract that builds in its ability to recoup its overall costs to provide water service. Now, a moment ago, the PD's position is that we can only update the numbers based upon new costs. That's just not what the contract says. The contract uses the word adjusted, which in our reply, we talk about the shall language. The adjusted means accommodated to suit a particular set of circumstances or requirements in Merriam-Webster's dictionary. That means basically what we're doing here is we're accommodating their rates to account for cost of service and the rates paid by other wholesale customers. So it is not as limited as PD wants it to be, which is just plugging in new numbers to existing line items. The contract never gets anywhere close to that specific when it talks about that Exhibit J. Finally, importantly, the contract states, goes on in section 5.10 for a while, acknowledging the fact that it exists within a realm that is very regulated, which is the water rate setting industry, and states the terms and conditions of this contract shall be construed and interpreted in accordance with the laws of the state. PD is telling you that the laws don't apply to this contract. Number one, that reading of the law is not right, and we'll show the court why. It's a little bit of common sense that you don't have contracts that override the law. The law controls the contract, not the other way around. But we'll show the court the reasons why. But the contract specifically acknowledges that it will be construed and interpreted in a way that is legal. So to the extent PDE says, this is our interpretation of this contract language, EP Water says that's not correct. But it's to a certain extent, the contract language is beside the point, because the rates that PDE proposes to pay, if allowed to persist over the remaining 40 years of this 60-year contract, would be illegal, would discriminate against other users in the city, and would allow PDE to pay preferential rates that nobody else gets. And, you know, we just don't think the contract intended to go this far. And PDE is, a lot of this argument is a bit of a stretch. Let's talk about EP Water's wholesale customer class. PDE is grouped within a classification that includes a total of 7 wholesale customers, all of whom are located outside the city limits. So some of the other wholesale customers are entities like Fort Bliss, the Fort Bliss military installation, Your Honor, the Lower Valley Water District. El Paso County has a number of wholesale customers under a contract that's consolidated. There were 11 until recently. Now there are 7. EP Water has a standard wholesale rate model. This is not in dispute, that is used for all those folks. And PDE's rates from 2003 to now have been determined, have been charged according to that standard wholesale rate model. The suggestions that PDE is making now are really a sea change, that they branch off and get their own rates that are no longer in conformance with that overall wholesale rate model, which is, that result is contrary to the contract and the law. And what happens is each year the utility does go through a rate update process that adjusts our standard wholesale rates that's used to calculate the rates for all customers. Now, what happened was in 2021, this is the rate update that is the subject of this lawsuit. So 2 things happened. We're in agreement on that. Number one, there was an update to the utility's overall wholesale rate model. It was not specific or individualized to PDE. It was not targeted at PDE. It was a change to the overall PSB wholesale rates that PDE agreed to abide by. Specifically, the 10% city payment was included in the bills for all of EP Water's wholesale customers, including PDE, and there were a couple of reasons for it. Number one, I mentioned a moment ago what the bond ordinances require. The bond ordinances require that says the 10% applies to all water sales inside and outside the city. And the utility looked at the situation and said, you know what, we are required to pay these funds from all water sales revenue, including the wholesale customers. And to the extent it was not done up until this point, it was, the wholesale customers have benefited from it, but it is required of us by bond ordinance. And so we have to pass it on. So that was one reason to comply with the bond ordinance. The other reason was to treat the wholesale customers equally to the inside city customers who have been paying the 10% as part of their water bills for several years. So Your Honor, you are correct that nothing about the 10% changed in 2021, and we freely admit that. But it was something that should have been assessed against these wholesale customers earlier. If it didn't happen, that's great for them, but it was an update to the overall model, and it is not, the contract requires us to charge it to PDE, pure and simple. The second thing that happened in 2021 was specific to PDE, but again, the underlying reasons were rate equality. By 2021, PDE, in 2003, when the contract was signed, PDE was brand new. It didn't have any users. It didn't even have a delivery mechanism to deliver water to those folks. It was dirt, as Mr. Davis said in our hearing last week. It was just pasture out there. There was PDE didn't have its own customer-specific peak data. So they were allowed to use system-wide until they established their own. By 2021, PDE had developed its own stabilized data, and the utility, like it's done with other wholesale customers, like it does with other inside city customers, says, okay, you've now developed your own stabilized data. There's no way for us to charge you rates based on system-wide that actually recover cost of service. So we're going to use your data, your water use data, to calculate your rates, because it's the only way to get to cost of service. And again, it's the only way to treat PDE equally to other retail and wholesale customers. PDE has resisted both of those changes. And it has been, which has been kind of characteristic for the relationship between the parties. There have been other instances in the past where PD has resisted rate updates. They have a very aggressive attitude in terms of trying to interpret the contract. Let's put it that way. Our position is pretty simple ultimately, which is that let's talk whether you slice it contract interpretation or whether you go rate setting application. We think that in either case, when you look at it carefully, that the utility should prevail. Under the contract, a complete accurate reading of all terms shows that the contract not only allows but requires PDE's wholesale rates to be adjusted to include both disputed charges to accomplish the overall arching principles of cost of service, and that they will pay the same wholesale rates as others. PDE's response is saying, well, you can make updates, but they're limited to plugging in new numbers to the existing set parts of the Exhibit J that existed in 2003. And that's just not what the contract says, and we'll show the court that. The second part is, to a large extent, the contract issues are a red herring, because we cannot interpret the contract in a way that's illegal. We can't give 20 or 30,000 residents vastly lower water rates than everybody else without some legitimate reason for doing it. And PDE's rates would be illegal. Texas law under the government code generally requires customers' water rates to be equal and uniform when they're subject to bond obligations, as this income is. As to wholesale customers specifically, the law says rates for all similarly situated customers have to be calculated on the same basis. That's specific to wholesale folks, and specific to MUDs like PDE. That's in the water code. And then these two statutes are effectively a codification of many, many years of Texas common law, which is held that utilities cannot engage in rate discrimination. They cannot engage in allowing one customer preferential treatment. So, this lawsuit is about PDE's contract interpretation, but ultimately the contract and the law say we're going to comply with Texas law. And that's what has to happen here. Let's talk a little bit about what the other customers pay. So the inside city folks, these are all of the folks that are inside the city limits. Summary judgment evidence shows there are 839,000 residents in El Paso County, according to the 2019 census. EP Water provides water service to 97% of those 839,000 folks. Within the city, this equates to a total of 220,000 separate connections, meaning homes, businesses, commercial, residential, commercial, industrial connections. Every single one of those 220,000 connections pays a 10% payment. Every single one of them has their rates calculated on the basis of customer specific peak information in the form of a customer classification. Everybody pays both of these expenses. The wholesale customers, we have at current 7 wholesale customers. This is part of an expert report that was prepared before the consolidation to 7, so it lists 11, Your Honor. How do those wholesale customers handle the 10%? It is charged forward and paid by all of them except for one that doesn't buy water from EP Water. There's one exception to the 10% payment among the wholesale folks. That is the Lower Valley Water District. And the reason is the Lower Valley doesn't buy water from the utility. Lower Valley has its own sources of water, and the 10% payment applies to water sales. So we don't have any authority to charge it to Lower Valley. And then secondly, there's one wholesale customer that does not pay based on its own peak data, and that is the Fort Bliss military installation. And the reason is, again, very specific and very understandable, is that Fort Bliss has predominantly its own water sources. It only acquires, it gets less than 25% of its water from the utility. And then the contract between Fort Bliss and EP Water contained a whole lot of other specific, highly valuable concessions worth millions of dollars. We're happy to talk about these very limited exceptions to our uniform rate model, because all they do is go to show how different these circumstances are than PDE, who has nothing like this. They didn't assign anything of value to us. They get 100% of their water from the utility. They're really, their services are unremarkable and compared to other wholesale folks. So there's great uniformity in the way that we charge water rates. Every customer that actually buys water from EP Water pays a 10%. And with the exception of one customer out of 220,000 in-city connections and another 7 wholesale customers, we have one exception. One customer doesn't pay their peaking, and there are specific reasons. PDE's suit is an attempt to extend the treatment that they want, which is going to result in them paying much lower water rates. They make no bones about it. Their position is the contract guarantees us a specialized rate methodology. It's basically, they're saying we're entitled to special treatment. There is no one, I've already been through these 2 points, Your Honor, but there is no one customer anywhere, in city, outside city, that avoids both of these disputed charges. This is this is a huge suggestion on their part that they should avoid both of them. And ultimately it comes down to very stretched interpretation of some of the contract language. The 10% city payment, let's talk about this for a minute. I don't want, it's been dubbed a surcharge and so forth. In this case, it is entirely legal to have a 10% city payment like this. The government code, chapter 1502, authorizes a city to create a public water utility and then give them the authority to control and operate the public system. EP Water is, they report to the city, but they operate autonomously from the city in almost all respects. The city decided in 1952 to create an independent water utility. The EP Water has its own board. They have its own administrative offices. They have their own administration, their own employees. And they have a lot of, they have employee forces filled with engineers who work very, very hard every day and do yeoman's work to try to plan for and provide water and wastewater and stormwater services within the Chihuahuan Desert, which is no small endeavor given the demands on water these days. In exchange for having this publicly owned utility that does nothing but think about water provision, the city of El Paso, like other cities, is allowed to require a general fund transfer. It's specifically allowed in section 1502.059. Says cities can adopt bond ordinances requiring a general fund transfer like the 10% to be paid to the city from the system revenues. The utility calls it its creation ordinance is bond ordinance number 752, which was adopted in 1952 and has been extended through several bond ordinances since. They are required to pay all 10% of all water sales revenue to the city. It is non-discretionary. It is part of our normal operating costs. It is booked as an operating expense on our financial statements, which are in the summary judgment record. It's just simply something they have to do. Lower Valley was never assessed at 10%, and evidently the exclusion of the 10%, which was part of the standard wholesale rate model, was passed forward and allowed, and some of these other wholesale customers that came online more recently benefited from avoiding the 10% for some time, and that's great for them. But we're required to charge it forward. This Texas Supreme Court has looked at general fund transfers like the 10% and specifically said that they are legal and allowed. There's a case out of involving the city of San Antonio. San Antonio has its own water utility that is created under the same authority as EP Water. It's basically a mirror image of EP Water in San Antonio. It's called the San Antonio Water System. So they're called SAWS. Several years ago, a group of public independent school districts in Bexar County filed suit against SAWS, saying that you can't include this general fund transfer. It's a tax. It's improper. It's not part of your cost of service, so forth. And the Supreme Court said, no, it's specifically allowed under statute. It can be legally collected from those customers as part of monthly water bills. Those plaintiffs were public entities like Paseo, and the court said that it's allowable. I won't bore the court with the details, but basically the court said, look, when a city creates a public utility, they're making a decision not to have a private investor-owned utility, and the city is foregoing certain ad valorem tax revenues, which can be replaced with a general fund transfer. So it's specifically allowed. Let's talk about the peak factors for a minute, because I want to make sure that we're explaining our position on this very carefully. Basically, a customer's water rates should be based on their own usage. And the continued use of system-wide is going to mean that PDE's rates have almost, in terms of the rate setting process, has nothing to do with their own water use, which would put them in this elite classification of wholesale customer, or that nobody else gets. A peak factor is a measurement of the maximum amount of water use compared to the highest use months in the summer compared to average months. The reason it is critical to have a customer's peak factors be part of their calculations is that the utility has to purchase water. They have to have water delivery facilities available to provide service to the customer at all times, not just in the busy summer months. So they have to have transmission lines large enough to meet the customer's peak demands. They have to have water set aside to meet the customer's peak demands. All that costs money. And that's why the use of the customer's own data has to be used. Otherwise, you're not going to account for true cost of service.
Mr. Weller, well, okay, so then on that point, then why not include that in the contract? For example, in 2003, or when you all went back in 2007, amend the contract or agree that after, I don't know what the appropriate period would be, after 10 years of customer usage. I get why that was subbed in, right? But that is I guess a circumstance that was going to change. So before you enter into a 60-year contract, you might want to have in the contract a provision that says, after 15 years of using, I would call them like sample rates, we're going to transition, because then we will have the data. Why not just do that?
I suppose they could have done that, Your Honor, and it's a fair question. But the issue is they have other contract language that effectively does the same thing, because it says cost of service rates. And there's no way to get to cost of service rates really without customer specific peak data. So, there's another wholesale customer that went through the same process. Gaslight Square, MHE, was another startup wholesale customer that was put on system-wide data during its development period. And then in 2010, the utility said, you seem to be mature, we're going to put you on your own data. Your Honor, if you go to the EP Water website and look at the web page that talks about in-city folks, there's a discussion in there about using system-wide data for them until they develop their own peak. And it refers to average winter consumption. So this is not new treatment. I don't think anybody at the utility actually expected that PDE would legitimately dispute being put on their own peak data, because nobody's ever taken this position before. And we think the contract contains terms that make it clear that this was going to happen. If they really expected this wasn't going to happen, I don't think they should not have. because nobody else gets that treatment. They admit it's not. PD admits in their petition the system-wide data was only used because at the time Paseo didn't have any of its own residents or users. It was a stopgap. It was a benefit to PDE, and system-wide was used from 2003 to 2021. In 2000, the contract was signed in 2003. Again, there was nothing there at that point, so it was impossible to use peak data at that stage. Customer-specific peak data, it didn't exist. PD didn't start accepting water until 2005. The last time that the rate methodology was actually touched was in 2007. Those changes primarily dealt with things like changing a fixed base differential, fixed payment. It didn't touch on these issues that are before the court. And at that point, PDE was still well within its development period. The depositions testimony has been, everybody's agreed to that. It was not even close to time in 2007 to move them over. I can show the court some of the data. But we're not trying to treat them any differently. We're trying to treat them the same as other folks. I've gone through some of this. I won't rehash it, but system-wide data has no relationship to their own water use. Everybody else in the city, when they use more water, their water rates go up. If PDE gets its way, they can use as much water as they want, and their water rates won't be affected, other than the fact that they're going to pay for the water they get, but the rate at which they're charged will not be impacted. So it removes, in large measure, PDE's motivation to conserve water. It would the analogy I think we put in our reply, Your Honor, is if you have, Mr. and Mrs. Jones live on Elm Street, and if Mr. and Mrs. Jones' water rates are determined by the average of every user on the street, and that means they can use as much water as they want, and their rates won't go up. So, if you're a different wholesale customer, everybody else but Fort Bliss has rates calculated on peak factors, which means that if they use more water, the water rate is going to go up. If you are an in-city customer and your overall volume of water passes a certain number of gallons, when you go up to that next category, you're going to pay more for your water. PDE is saying we don't want to do that. We want to stay on system-wide. And the elephant in the room is because they know they use a lot of water and they don't want to pay for it. That's the issue. It's essential to cost of service for us to be able to recover, the water rates based upon the usage on their actual water usage. It's also the best data available. We just really didn't think this was going to be an issue. Nobody's ever taken this position or resisted something this fundamental. This is the Exhibit J that's referred to so much. I just want to point out a couple things about it, okay? There's Mr. Green went through the payment to the city exclusion. It was a less cost exclusion. Well, let me go back for a minute. Here's the payment to the city. It was an exclusion in 2003 and there's a specific reason for that, because it wasn't part of anybody's wholesale rates in 2003. This was not individually negotiated by PDE. There's just no evidence of that. This is, there's a statement down here at the bottom of Exhibit J, the 0304 rate update prepared by Rick Giardina, who's our expert in this case. This was a statement of the wholesale rates that applied to everybody in 03. It was not this particularly negotiated benefit of the bargain thing. There's just no evidence that the parties negotiated this specifically. The contract was lengthy. They negotiated other things, but not this. The payment to the city was an exclusion at that point because it was an exclusion for all wholesale customers at that point. This conservation credit right here, that's what I was talking about a minute ago. If this methodology is fixed in stone forever, then how come this conservation credit's not in there anymore and it's gone? The conservation credit doesn't exist anymore. This was a credit that was provided to in-city customers who were purchasing high efficiency fixtures like high efficiency toilets.
Mhm.
This program phased out in 2009, 2010. It dropped out of the less cost exclusions. It's not there anymore. And PD agrees, okay, yeah, we're not entitled to that. So that's an example of how this document is a living, breathing thing. We can't meaningfully account for all the expenses that cause all of these line items to change every single year if we can't change based upon changing conditions. It's a cost of service agreement. So if we have new expenses, then these total system O&M and capital costs numbers are going to change based upon brand new things that came along this year. If we have to build a new desalination plant, this number is going to change. And these adjustments or updates, however you want to call them, are not different than the idea of saying, look, we made a change to all the wholesale customers. The payment to the city is not provided as a cost exclusion anymore. And once your peak data became available, they did was they started subbing in. There's the wholesale units. This is the line item that drives the peak data issue. So it was wholesale units in 2003. And this number right here, the 50,558,000 CCFs, those are system-wide numbers because there wasn't anything else to use at that juncture. So it was impossible to use their own peak, but there's nothing in the contract, Your Honor, there's nothing in Exhibit J, there's nothing in other parts of the contract that ever uses the word system-wide or says this is going to stay forever. The system-wide data was dropped in there without comment because there was nothing else to put in. So they're trying to make a mountain out of a molehill with a lot of stuff. So these are the peak rates that Mr. Green talked to you about a minute ago, and we're going to explain why we didn't use their peak during the early years. So 07, 08, let's use that as an example. PDE's individual peak rates were 622. System-wide was 192. Okay, so as the years go by, as PDE builds itself up, as it develops, as it establishes a normal history, you see PDE's peak rates normalize and level off right around here in 2016, 2017. EP Water didn't try to put them on their own peak in any of these prior years. They waited until it looked like PD had developed its own particular use history. This is like, I don't know, Your Honor, the best way I can describe this, if you've ever had a water break at your house, you have an irrigation line break, and all of a sudden 1 month your water usage just jumps up, right? So if you, at least in the city of Austin, our water rates are outrageous, but compared to El Paso, but if you submit a repair receipt saying, look, I fixed it, it was an outlier, the city will say, okay, no problem. We'll make an adjustment to your water rates. It's the same concept here on a much bigger scale. The utility knows that when a brand new customer comes in like Gaslight or PDE, these initial years are outliers. They're not representative of PDE's normalized usage. It doesn't mean we're not incurring expenses to provide this water. It just means that the city is saying we're going to, give you a break until your usage normalizes down here in 16, 17, 18, 19. So PDE benefited greatly by the city allowing them to do this. Here's an example of what their rates would have been like during those years. So again, this is from our rate expert, Ref Tellis, part of their expert report. In 2010, PDE's own peak factors would have resulted in water rates of $2.57 per CCF. System-wide, they were allowed to pay $1.53. So their rates would have been 68% higher. That's why they weren't put on their own peak before that. They would have been howling if we had tried to put them on on their own peak at this point. They would have said, we're not ready yet. We're not developed yet. And now when we try to move them over, no good deed goes unpunished. But this is the real issue here. So even after they normalize, Your Honor, 16, 17, they pretty much reached a point of stasis. Their rates, their peak rates are higher than system-wide. They use more water every year almost than the system-wide numbers. That's why they don't want to change it, because this will account for their actual cost of service. That is the elephant in the room. We're not trying to treat them differently or unfairly. We're trying to treat them the same as others. Maybe it could have been clearer in the contract, Your Honor, but the contract contains terms that get us to the same place, honestly. PD's position, let's talk about their position for a minute here. Let's talk about this Exhibit J. They're saying that Exhibit J was a specific, detailed, agreed upon methodology. They take this position that it had to be used for the entire 60-year duration of the contract. So we're supposed to predict the future in 2003, and it can never change. They rely heavily on one sentence plucked out of Section 4.1, and they don't really give effect to the other language around it. This one sentence generally states that the methodology in Exhibit J would be used in the future. It never says for the whole contract. It never says you can't change a single assumption or line item. It just says the methodology. The methodology is still being used. Almost everything in it is still being used. So we think they're overreading this sentence as well. Let's talk about the contract interpretations, okay? And I'll go through some of the language with the court. Their suit is contrary to the contract. The 10% payment is allowed because the contract states several times, PD's rates shall be automatically adjusted. Automatically adjusted. Not with a, we don't have to sit down at the table with them every time there's an adjustment in our costs or we think it's appropriate to put them on their own peak. That's not what the contract requires. It says automatically adjusted as we adjust our wholesale rates. Therefore, their rates have to follow the PSP wholesale rates. They can't branch off. And in 2021, the utility says, we needed to have included this 10% payment. We're doing it for everybody at the same time. We're applying it across the board to all wholesale customers at the same time. PDE, you need to pay it. And then customer specific peak data, again, the contract addresses and resolves all these issues already. It states that PD's rates are to be automatically adjusted to include cost of service. And it goes on to say current cost and customer information. So it says current cost information, current customer information. In other words, PDE's current cost and customer information. And then it also says the same to accommodate the PSP wholesale rates. So again, this theory, if the other wholesale customers are paying based upon their own peak, there's no reason PDE should be able to avoid that. And there's just no way to get to these points in the contract if we continue to use system-wide. The contract has to be read in harmony. Contract Law 101. Our reading of the contract is the only one that really fairly looks at everything and says, yes, everything has effect, not just parts of it having effect. When construing a contract, we're supposed to read everything together to ascertain the parties' agreement must be considered as a whole. Each part should be given effect. Our interpretation gives effect to everything. And basically what it is that, yeah, in a lot of years, it may be a limited to inputting numbers into a set formula. That does not mean that the contract doesn't also say that when you make an adjustment to the wholesale rates, the PD is carried along. And it does not mean that PD gets to avoid cost of service by paying system-wide peak data for the whole contract. So, yeah, I mean, in many years, it may just be inputting numbers, but that does not amend the contract. Contract terms supporting the 10% city payment. This is what a more developed look at all the contract language says. Section 4.1 and 4.2 are the sections that address PD's rates. It makes it abundantly clear PD will pay the then current PSP wholesale rates, not PDE's rates, the EP Waters rates. says, this is the first sentence of the section. The first sentence, section 4.1, for all water service provided by the PSP to the district shall pay the PSB an amount equal to the PSB's then current rates for wholesale service. And then it defines it as PSB wholesale rates, plus this base differential amount, which was to repay, which is different, which is to repay some of the infrastructure expenses. So first sentence defines their rates as matching our PSB wholesale rates. Goes on in other parts of 4.1, starts calling the rates that arrived at an Exhibit J were initial rates. Initial wholesale rates were 94 cents per CCF. That's what matches up to the calculations in Exhibit J. 94 cents per CCF is what PD paid in Exhibit J. This is the sentence PD relies upon. They pick it out. We have to read it in context. It says the PSB agrees to the same methodology that is used to calculate the initial PSB wholesale rates, which methodology is set forth in Exhibit J to fix the PSB wholesale rates for the district in the future pursuant to this contract. The very next sentence says, yes, although you do have initial rates, the part of the rates for water supplied under the contract consisting of the PSB wholesale rates shall be automatically adjusted as the PSB adjusts its PSCB wholesale rates. So you have to go to the next sentence and it says, yes, you have initial rates, but if there's a change to the wholesale rate methodology, you go along with it. Another point in here that I think is important, Your Honor, is the contract doesn't say Exhibit J will be for the entire contract. Later within section 4.1, it refers to a different type of charge, the base differential amount, and the parties come out and say fixed for the term of the contract. So when they talk about Exhibit J, they say in the future, and then when they want to make it clear that something remains for the whole contract, they say fixed for the term of this contract. So when we construe the contract, we're supposed to assume every word is used for a reason, every word is excluded for a reason. They just didn't say it was going to be fixed for the whole contract. When they wanted to say that, they came out and said it. I'm sorry, this is more or less the same point, but basically it uses the word initial rates. It does not say forever. When they want to say fixed for the term of the contract, they come out and say it. It's in the same paragraph of the same section. So clearly, if they wanted to make it last forever, they would have said it. Contract terms supporting the use of customer-specific peak factors. PDE's petition agrees that the rates to be charged are based on cost of service. There's no dispute about that. And what does that mean? Well, there's no way to get to cost of service without their data. It says the cost of service analysis is updated annually. Section 4.2 is the section entitled rate methodology, and it says the cost of service methodology used by the PSB to establish wholesale rates as described in Exhibit J applies to the development of rates for both retail and wholesale service. This is a direct reference to the fact that Exhibit J is the same thing that we use for others. That's what they're saying here. They're saying this is not a specialized methodology. You're being carried along and paying rates the same way as everybody else. It's a cost of service methodology. And then it says the cost of service analysis is updated annually using current cost and customer information. So in 2021, the current cost information, the current customer information was their own peak data, which had been developed enough for it to be used. PDE agrees. I'm going to quote some of the language cited in their response to our motion for summary judgment. They agree that the methodology can be adjusted. Adjusted means changed, not updated. The methodology is, they state this in their response. The methodology formula must remain unchanged, notwithstanding that the numbers inputted can and will change from year to year.
I'm sorry, can you read that again?
Sure.
Slower.
It says the methodology, this is a quote from their response. And they're saying their interpretation is the methodology has to stay the same, but the numbers are inputted into that formula and those numbers can be updated. But then they go on to say this. So section 4.1 of the contract confirms while the methodology remains the same, the variable components within that methodology will be subject to annual adjustments. That is what we did with the peak factor. The circumstances have changed. Like a cost increase that comes along, it's brand new. The circumstances have changed. The circumstances where your peak data is now reliable, and we believe it's the best way to calculate your rates. So here's what happened between 2020 and the 2020 rates and the 21 rates. This is the change. It was not a elimination of a less cost exclusion. The only thing we did was, it's right here in under base flow, this column for base flow, you see Paseo del Este units of service. This was system-wide in 2020-21 rate update. And then the next year, what they did, you can see that's 45 million CCFs. This is still system-wide. Then you move on to 21. All they did was substitute in updated information in much the same way that you substituted updated cost information all along this line item. It's just more accurate. It's a more accurate calculation now.
And up above, I mean, it does say on the payment to city, that's zeroed out, right?
Yes, Your Honor, it does. And I can go back and let you see that carefully. So the utility didn't, let's go back to 2021. Okay, so here's the payment to the city, payment to city O&M, and you see that there is what was still a cost credit across all wholesale customers at this point. These less cost exclusions are not specific to a customer. They're applied across the board to all the customers, all the wholesale customers. So the utility's not trying to hide the ball. They just said, look, the payment to city, they didn't take it out. They just zeroed it out. So they did remove it as an exclusion, but the contract allows for it. So, but what ends up happening here is the CCFs go from system-wide to individual. Right here, at PDE's specific usage is 1.4 million CCFs. And part of the reason it's so important to use customer-specific peak data is residential users are predominantly what PDE has. Residential users are traditionally the highest peakers. That's why it's so important to use peak data for PDE, because they don't cost less, they cost more than our other customers. They have some of the highest peak rates of any of our wholesale customers. Their peak rates are much higher than, so when you use system-wide, you're using commercial uses, you're using industrial uses, these are office buildings. Those numbers should not be used permanently for high residential peakers. We asked, here are the conclusions of both rate experts on both sides. So our rate expert is a gentleman named Rick Giardina, very well respected rate expert. PDE's rate expert, they have a guy named Jay Joyce, who he's presented their conclusions on their standpoint from the rate setting perspective. They both agree that customer specific peak data is the most accurate way to reach cost of service. So here's the question I asked Mr. Joyce. So what I'm asking you is whether the use of system-wide peak data is going to accurately capture the cost that a utility incurs to provide service, or whether you think the use of customer individual peak data would more accurately tell us the demands that customer places on the system. And the answer is, if it's calculated correctly, then an individual peak would most likely be more accurate if it's calculated correctly. So he agreed that the utility's way of getting to cost of service is the more accurate way. Mr. Giardina stated the following in his expert report in the summary judgment record. He states the use of water demand data is a key factor in the determination of cost of service-based water rates. He states the continued use of system-wide demand data would result in PDE paying rates that do not reflect cost of service. So I want to emphasize this, if I may. The utility will take a loss for the next 40 years on PDE if we don't use customer-specific peak data. And then Mr. Giardina goes on to say, I am not aware of any utility that as a matter of standard practice uses system-wide data in the development of rates for a class of wholesale customers, let alone any individual customer, or for that matter, a class of retail customer. So and then Mr. Joyce testified to the same thing. He says, I've never seen a wholesale customer use system-wide for the entire life of the contract. This is just a far out theory, which is, I think, part of the reason the utility felt that the contract language dealt with it. So what happens if they don't share in the disputed charges? A lot of this is, I think it's almost more helpful to look at it from the inverse of what will happen if we don't do these things. There's no way to harmonize the contract is the short answer. Several of the most basic agreements would be ignored. So PDE would branch off from all the other wholesale customers by not paying the 10% or not paying the peaking. They would receive their own individual special rates that would be much lower than everybody else's. And those folks that live in that mud would pay by far the lowest rates of anybody inside or outside the city. And the contract just doesn't support that. Everything is to the contrary. The contract defines PD's rates as the PSP wholesale rates, not individual rates. And then secondly, as I mentioned a moment ago, the rates would fall below cost of service by using system-wide. We took the depositions of the two signatories of the original wholesale contract and the 2007 amendment. Those gentlemen are Jack Holford, who's the president of PD's Board of Trustees. He lives in Austin, along with all the other members of the board. They hold their board meetings in Austin. Mr. Holford and then we took the deposition of Ed Archuleta. We drove out to Las Cruces, where Mr. Archuleta lives now. He's retired, and we took Mr. Archuleta's deposition. He's the former president of VP Water. These were the two guys that signed the contract and the amendment. And here's what they said about the Exhibit J. So Mr. Holford said, I'm going to ask you, PD's position is should not pay the 10%. Do you remember any consideration or thing of value PD provided in exchange to never pay the 10%? And he says, well, first of all, we never heard of it until 2021. It never came up at that point. I never heard of it. And I quit the question. So it's not part of the negotiations? No, sir. It wasn't negotiated. There weren't negotiations on this. This was a use of Exhibit J is a statement of the other wholesale customers' rates. It was not specifically negotiated. They didn't offer anything of value to avoid this stuff. And then we asked the same question on the peak issue. Do you remember any consideration or thing of value PD provided when the contract was signed in exchange for an agreement that PD's rates would be based upon system-wide peak data? No. And then Mr. Archuleta was asked the same thing. He still has a very sharp memory, very vivid memory. The question, obviously, we have a lengthy wholesale contract here between the utility and PDE, a number of negotiations on things like the construction of initial improvements, things of that nature, which is true. Do you recall negotiations or discussions about the details of exhibit? Yes.
I need you to slow down when you're reading, please.
I'm sorry. My apologies. The tendency to read quickly. Do you recall any negotiations or discussions about the detail of Exhibit J that I was involved in? Yes, sir. The details, yes, sir. No. Does it look like a special age rate model to you? No. Is there anything about this rate model that is unusual for the treatment of a new wholesale customer? No. We had developed a rate model that was developed by Rick Giardina at that time many years ago, and staff was educated and trained to use the rate model, so we followed the same rate model for years and years. And this page is just an example of other utilities that would have had a similar type of spreadsheet or whatever to show how the costs are allocated and how they're arrived at. Question, so when the contract was negotiated, do you remember PDE offering any consideration to the utility in exchange for an agreement that PDE would not pay the 10%? Answer, no. Same question for the peaking. Do you recall any negotiation or consideration provided by PDE in exchange for an agreement that they would never forever pay rates based on system-wide peak data? Answer, no. So it was not part of this negotiation. Let me move on to the legal issues, and I'm sorry this has taken as much time as it is, Your Honor, but the question before the court on the legal issues, setting aside the contract interpretations, in any event, does the law permit PDE, who is an ordinary wholesale customer, to pay water rates which are lower than all other customers and calculated in a way that's different than all other retail and wholesale customers? It's calculated differently because nobody else has water rates calculated based upon usage that has nothing to do with their individual usage, like PDE suggests. The answer is no. This rate structure is illegal and would violate multiple rate setting laws and standards if allowed to persist for the next 40 years of this contract. It would violate Government Code 1502.057, Water Code 13086, and Texas Common Law. It would create preferential rates and a lead classification for PDE. PDE is telling us that the contract controls all the law, which is just not, defies common sense. And the part of the issue here is that if you know, the utility is in many senses in this lawsuit representing the other users in the system and the other wholesale users, and trying to assure the integrity of their rate model and that it stays in compliance with the law. What would happen if PDE avoids both of these expenses is that it would give them a special set of rates and would expose the utility to potential legal action from the other wholesale customers and the other retail customers, who might come in and say, that is preferential, it's illegal. How do they get this treatment and we don't? There are two statutes that are on point. One of them is in the Government Code, 1502.057. This is the same chapter that allows the utility to be created. And the law has rate covenants in it. In other words, requirements that the rates may fall no lower than this. It states that the municipality has to impose charges for services in amounts at least sufficient to pay all the operating expenses, the interest in sinking, and outstanding debt against the system. This is clearly intended to deal with situations where revenue bonds have been issued. Again, and those revenue bonds are secured by the revenues from the system. So in other words, the operating income is part of the security for the bond. And those bonds are necessary for the utility they use that income to supplement the income they get from the ratepayers to maintain and operate the system. So what this statute is saying is, if you take out a note on public facilities, which is basically what the bonds are, you have to at least collect enough to pay down these obligations. And then subsection B says the rates charged have to be equal and uniform. So in other words, if the whole public system is encumbered by an outstanding bond, you can't have special treatment. You can't start allowing this customer and that customer to get special treatment, because if you were to do that, and that continues with other folks, with other users, then you may be jeopardizing the security for the bonds. So if we have a bunch of people that get special rates, then potentially, their income may fall to levels where they have to raise rates or take out more bonds to fund the operation of the system. That's why you have these rate covenants when you take out a bond. The second part of the law is Water Code 13086, which deals specifically with wholesale customers. It says the rates have to be fair, and they have to be, the utility is required to determine the rates for the sale on the same basis as other similarly situated wholesale purchasers of the municipality's water. Subsection B is important. It says this section does not apply to the sale of water under a contract executed before the effective date of this section. The effective date of this statute is 1997. Before this contract was signed, the contract expressly says it's subject to the law, will be construed in accordance with the law. So, what this subsection B is saying is, effectively, We're carving out contracts that exist before the law came along, but everything that comes along after this is subject to this law. The legislature is saying you don't get a contract that gives you special treatment. The law controls the contract. Texas common law, the longstanding rule has been a utility cannot discriminate or provide preferential charges or services between similarly situated folks. Black versus City of Killeen is an example. It imposes a duty on utilities to say public utilities have a
I'm
duty
sorry,
to
what is the
charge.
case? Give me the case name again, sir, please.
Sure. Black versus City of Killeen, 78 Southwest 3rd, 686. It's out of the Austin Court of Appeals. It imposes an affirmative duty on public utilities like EP Water to charge reasonable rates and ensure they are not unduly discriminatory. Caldwell versus City of Abilene from the Eastland Court of Appeals, explaining utility service must be given without discrimination between persons similarly situated or under circumstances substantially the same. Texarkana versus Wiggins from the Texas Supreme Court. It's a different concept, but related. When a utility creates classifications among customers, they cannot discriminate between those similarly situated. We have a wholesale classification, and we can't give one customer different treatment. One thing about all these cases that I think is important, Your Honor, is that in the circumstances where a customer is allowed to be charged more, there is a clear rational cause and effect that the analysis the court goes through. They're not different just because they feel like they're different. They have to be legitimately, there has to be a not an arbitrary reason. It has to be a legitimate fact basis justification. So in one example, a customer was allowed to be charged higher rates because they were geographically located so far away from the city that it costs more to transmit water to them. So there's a cause and effect. It's a rational thing. It's not just, this customer, they have their favorite color is blue, and so they're different. PD has not been able to point to anything that makes them legitimately different than anybody else. And I'll go through that in a minute. One other point about the rate making decisions. The utility is the rate making entity here, and their rate making decisions are presumed to be legal. In this instance, the utility has looked at PDE and the other wholesale customers and said, guys, we're not aware of anything that makes you legitimately different. PDE's claiming that they're different, but the utility knows the circumstances of its customers, and there's nothing that differentiates PDE in any meaningful way. The terms of their service are pretty unremarkable, actually, other than the fact that they use a lot of water. The burden of proof is on the party challenging the rate. PDE has the burden to show that they're different. We attached the affidavit of the utility CFO, Arturo Duran, who went through some of the facts about PDEs compared to other wholesale customers. There's no rational justification for them to receive lower rates. PDE would need to show that their service costs less, and that's not the case. It costs more because of their high peak rates as compared to others. All 7 wholesale customers, are outside the city limits. They all have contracts based on cost of service. They all go through rate updates every year. PDEs uses the same rates as everybody else. There's just no justification for it. PD has not shown that they're differently situated. There have been a variety of things they've kind of thrown out as the case has gone forward, and they've kind of walked away from some of them seemingly in their response because we sent them an interrogatory request saying, how are you differently situated? They gave us answers, and they didn't point back to those things when they answered our motion for summary judgment. It's been kind of a whack-a-mole experiment trying to pin them down as to how they say they're different. The latest contention is that they're not similarly situated because they didn't have an existing water system when they entered into the contract. And they're saying this explains our ability to insist on avoidance of these charges. The utility was allegedly trying to avoid an adjacent competing water utility. So they're basically saying we were a new customer, but they're no longer a new customer. They now have their own peak rates. They're not entitled to new customer treatment forever. The second thing, there's no impact. There's no evidence that this concept of a competing water system impacted negotiations. There's no evidence that either of these things were negotiated, the disputed payments. There's just no record of that. And then, like we said, EP Water has a set system for new customers. The initial lack of a water system was addressed by the transition from system-wide to peaking. So that shouldn't persist. Finally, I just want to make one last point here. The contract says it's to be interpreted in accordance with the law. So it goes out of its way to say this at some length. Validity, operation, and performance shall be governed and controlled by the laws of the state of Texas. And then it says the terms and conditions, this is the interesting part, the terms and conditions shall be construed and interpreted in accordance with the laws of the state. So the parties basically said, okay, so to the extent there's some misunderstanding about what the language says, you just fall back on the law. Finally, this point about 791.026, I just want to address this briefly. The courts have looked at this. This argument has been tried before. 791.026, and the courts have said it does not supersede other laws. Obviously, it does not supersede other laws. In Bexar County, Bexar Metro Water District, the Austin Court of Appeals acknowledged that interlocal contracts do not prevail over other provisions in the water code, nor could they. I mean, so the water code contains health and safety requirements. It contains CCN application requirements. We're saying that all a party has to do is sign something within the definition of an Interlocal Cooperation Act agreement, and they don't have to abide by the law. That can't be right. And the courts have looked at it and said, to be sure, the Interlocal Cooperation Act does not supersede the specific requirements. In one case, they said, doesn't supersede CCN application requirements. It's basically interpreted to mean if there's something that would directly prohibit us from signing an interlocal agreement, then that's overruled. But you're not going to have this almost like this final subsection in the interlocal section is going to operate with these huge sweeping effects and allow the parties to disregard every other law. That's just not that's not correct. Texas Water Commission versus City of Fort Worth. It's not San Antonio, it's Fort Worth Court of Appeals. Similarly held, the Interlocal Cooperation Act does not provide water utilities with greater rights or obligations than those afforded by the water code. This was another situation where the competition between this section and other law was examined, and the court said the statutory provision that the power to enter into contracts prevails over a limitation in other law refers to statutes or charters that might directly prohibit a municipality from signing a contract, does not preclude later legislative actions. They're saying you don't overread 791.026. That's the end of my presentation, Your Honor. I really appreciate your time.
Sure.
I know I've taken a while, but I appreciate you.
No, here's my issue though, is that I feel like we have a significant amount of hearing to go, at least more than I'm comfortable with. We're a couple of things. I haven't given Miss Wright a break, and we've been going for almost 2 hours. And frankly, I'm not inclined to just take a break. So as much as I hate to do this, because I know everybody's schedules are complicated, we can resume the hearing tomorrow at 1:30 p.m.
Your Honor, I can just take 2 minutes and be done.
Well, but I don't know if I have any questions. I mean, I may have a little more that I want to go through.
Okay.
And so 1:30 tomorrow, Zoom. Already. Thank you, Ms.
Yes.
Wright. Council, thank you very much.
Thank you, ma'am.